Okay, Shannon, put us on the record, please.
Okay.
All right, this is the matter of the Ball miners. Sorry to keep you all waiting so long. We were tied up with another off-the-record case that we were all trying to figure out some seldom used court rules and figure out how to go. They asked me to call this case first because we didn't think it would take quite as long. So for the record, we have Kelly Tucker representing the petitioner on behalf of the agency, Damian Brining and Sean Furlong. And let's see, Mr. Brown is LGAL. And I forgot who represents Mom.
That's me, Your Honor, Rebecca.
All right, I'm going to write that in the jacket so I don't have to remember. Mom is present by phone. And father's present in the hearing, and I think that's everybody. So we're having another pretrial today, trying to figure out how soon we can actually do a jury trial. I'm hearing that, well, maybe you can tell me for sure, Callie, is Judge Jordan doing a jury trial this week?
Not that I have heard.
I just heard a rumor that she was scheduled to do one soon. I wasn't sure if it was this week or not.
I don't think it's this week. Last I heard, but again, I'm kind of out of the criminal world at this point, is still looking at July to start them.
All right. And I don't know what our restrictions are going to look like in July. Things are supposed to open up considerably more than they are now. I guess the best I can do is maybe set another pretrial, our first available Tuesday in July. Certainly by then, I think I'll be able to set a trial date with some confidence. So Mr. Ball, we've talked in the past about the complexities of doing a trial, being a non-lawyer, but particularly a jury trial. I think one possibility that I haven't broached with any of the attorneys yet is, although you're going to be representing yourself at a trial, I think it's possible that I could appoint an attorney whose sole job is to assist you during a trial. You would still conduct your own trial, but that attorney would be available if you had questions about the procedure as you go along. Is that something you'd be interested in?
Yes, sir. Definitely.
And I can't remember who the last one I appointed was. Was that you, Mr. Hotchkiss?
Tim Williams.
He's going through health problems right now. So I don't know when he's going to be available.
Okay.
Let me ask, Mr. Hotchkiss, I don't know if you're listening in now or not. I know you're muted.
Gunner, I previously had been appointed and there would have been a breakdown of the relationship and you relieved me of that appointment.
Right, I understand that. What I'm wondering about is if Mr. Ball proceeds to represent himself and doesn't hire any other counsel, do you believe you could be present simply to assist him in any questions he might have about the process? You wouldn't be required to prepare. You wouldn't be required to present. All you'd be there is, and I know judges do this in criminal trials when criminal defendants insist on representing themselves. So even though you and Mr. Ball would disagree on legal strategy, he gets to use his own strategy. He gets to do it as he wants, but would have someone available if he has a question about procedure. Is that something that you believe, a role that you could fill?
I have no objection to that, Your Honor. I guess I'd leave that to Mr. Ball.
I agree to it. That's fine with me.
Mr. Hotchkiss is a very skilled, experienced attorney. I think he would be of great assistance to you just for some of the procedural stuff. You could have a conversation with him throughout when you had questions about something, but you get to proceed. You're driving the bus. He's just there to help you.
Yes, sir.
All right.
If I had money though, if I had money, I would have got a lawyer, but I don't have enough money anymore. So.
All right. I feel better about that than just turning you loose on a jury without the kind of
I appreciate
practical experience.
I appreciate that. That's definitely a help. Could I address the court for 2 seconds?
Just a second. Callie, was there anything else you wanted to bring up today, or any other attorney?
Yes.
I don't, Your Honor. Sorry, Ivan.
All right. And Mr. Brown, let me ask you, first of all, how are Mr. Ball's children doing?
Judge, I haven't had any communication. We haven't adjudicated yet. I haven't had any direct conversations with them. They're quite young. I'm just relying on what the worker says, that everything is going well with them.
All right. And you wanted to address the court. Go ahead.
Yes. Briefly, the court has taken care of partially what I was going to request regarding the attorney. You kind of preempted me there. Mr. Ball and I have had some email conversations regarding this case, and I think he's been receptive to what I have said. And I'm sure the court knows that I was quite direct in what I said to Mr. Ball, and he seemed receptive to what I have said to him. What's kind of troubled me in this case is because some of the actions that have occurred, this case could have been over by now. Take a couple classes, do what you're supposed to do, return home. This case could have been over instead of languishing. And that troubles me. And I think Mr. Ball may realize that at this point. I hope he does. I was going to ask the court to give it one more try with an attorney to see if Mr. Ball can be talked to. I hate this case languishing when it should be over by now. And Mr. Ball back in the home, if he had accepted or listened to Mr. Hotchkiss. Mr. Ball indicates he would hire an attorney if he had the money. Well, you're getting Mr. Hotchkiss, who many people would seek out for free. Trust what he says. Mr. Hotchkiss is, if I were going through something, I would hire Mr. Hotchkiss. So I'm just begging you to do that for your children's sake. Thank you.
So I've reappointed Mr. Hotchkiss in the limited role, but that doesn't keep Mr. Ball from seeking advice from him, even as to the merits. I would encourage those conversations. In the meantime, since we still have a jury demand, I can't schedule a jury trial yet. I'm very hopeful that at least when we come back in July, what's our first available Tuesday in July, Shannon?
13th.
July 13th. And hopefully by then, at a minimum, I will be able to tell you with certainty when this jury trial can occur. I think we'll know a lot more then, and I'm optimistic that things are going to move pretty quickly and in reopening. But in the meantime, Mr. Ball, I would encourage you to seek out Mr. Hotchkiss. Like I say, he's appointed in a limited role. You don't have to take his advice. And he's not conflicted in the sense that he knows you're driving the bus and you ultimately get to make the shots. He's just there to provide advice and guidance.
Well, thank you, sir.
Mr. Ball, is your number still 734?
Yes, sir.
Okay. Do you mind if I call you maybe sometime this week or next week to discuss this?
That would be awesome. Thank you.
Okay. I will give you a call.
Go ahead, Mr. Ball.
I definitely have been approaching everything wrong. I just miss my kids. So, and I am still taking counseling. I've taken all the classes. I'm doing everything they want me to do. I have counseling later today at 4. I was going to ask that, I know I can't go home. Obviously, that's the conversation we're having. So my daughter is graduating tomorrow at 10 a.m. from elementary school. And I would like to go. I'd like to start seeing them way more often. I don't know what we could do about that now, but there's no danger to my kids. I just, now that they've interviewed them, everybody's talked, and I just would like to see my kids. But, at the least, I'd like to be able to go to her graduation in the morning.
I have no objection to that.
Just 1 second. Can I just speak for just a second? It's been 6 months without him. And if we could just get unsupervised visits, that would be huge, because they are the only ones that are hurting. No one else is suffering in this case at all but my kids. So if we could please, we had the interviews, we've done everything. If we could please at least get unsupervised visits so he can pick his children up and help me, and we can start to rebuild our family, please.
Well, let's take the first request, which is attending the graduation. Is anyone have an objection to Mr. Ball attending his child's graduation?
Mr. Furlong, do you have any thoughts on that? I don't have an objection if Mr. Furlong is comfortable with that.
Good morning, Your Honor. I've been informed that he can go to it, but I would have to supervise, since it's still supervised parenting time, so I'd have to sit in the back.
We've got a crowd of people there. Is there really a need? I can certainly order that he be allowed to attend the graduation, and that CPS has no obligation to supervise the graduation. The unsupervised parenting time beyond that is a different issue. And before I wade into that, I want to address this. He's going to be at a school event. There's going to be other parents there. In that setting, I guess I don't see any danger.
That'd be at your discretion, Your Honor.
All right, Mr. Ball, you can attend your child's graduation.
Thank you.
With respect to beginning unsupervised parenting time, my inclination, Mr. Ball, you've indicated that you've been taking some classes and getting some services. Has that been verified by anyone from the agency, Mr. Furlong or Mr. Brining?
I've tried to reach his counselor, Ms. Cheeseborough, with no success. She will not return faxes that I've sent her for a release, voicemails. She's likely working out of the office. I've requested per my own group of coworkers for email for her, and trying to get in contact with her just to verify how it's going, and to verify whether or not she's received a copy of the psychological evaluation, so that her services with Mr. Ball can be based off the recommendations from Ms. Lauder.
So, Mr. Ball, is that the counselor who you're seeing?
Ashley Cheesebro, yes.
If you could, I want to get some independent feedback before I say unsupervised visits can begin. Okay. If we can get some verification from your counselor as to what exactly she's counseling you for, and are you making progress? I would be far more receptive to entertaining unsupervised visits, but I need something other than just you or your wife saying, we think it'll be okay. I need the agency to be able to look at the situation. Could you encourage your counselor, please, to respond to Mr. Furlong?
Yes, sir. I'm actually emailing her now, and at the very latest tonight, when I have my session, I will tell her what, what needs to be done.
Sign a release.
Yeah, sign a
that's what I
release
was-
so that she can talk to Mr. Furlong. And we don't have to wait until July 13th. Mr. Furlong, if you've got information to suggest that we could commence some level of unsupervised visits, I would certainly be willing to entertain an early review before this next pretrial date.
Yes, Your Honor.
Your Honor,
Okay.
for what it's worth, I just want to make it clear on the record, the court's order is going to specify that Mr. Ball can attend the graduation, but any other contact with his children shall remain supervised, correct?
Right. He can certainly have contact with his children at this graduation, but when the graduation is over, they need to go their separate ways.
Thank you.
And then
Thank
we'll
you, Your Honor.
revisit the issue of visits at a future date, certainly no later than July 13th, but even sooner if someone asks for an earlier hearing. Okay,
Thank you, Your Honor.
so you're welcome. July 13th at 8:30?
If that's when you want to hold the pretrial, yes.
Yeah, July 13th at 8:30. Thank you, everyone.
Thank you.
Have a great
You're
day.
welcome, ma'am.
Thank you.
You too. Progress. Okay, next up is Ellsworth. And let's see, I've got Haley Bordeaux. I think I saw her in there.
And for what it's worth, Your Honor, I've been texting with Haley a little bit, and she has more information regarding putative father than we had in chambers.
Oh, good. Well, I will take a little bit of testimony from her. I don't see Jackie Johnson. Let me run down the list again. Okay, otherwise, let's see, parents. Well, we're not expecting parents in this one.
Brandon Miles is the father, and he's participated in every hearing up to this point. He might be in the waiting room.
Unless he's signed in, excuse me. Unless he's signed in on someone else's device, I don't see him here. I've got one that it says N. Winans, W-I-N-A-N-S. Did anybody recognize that?
That's for Cavender, Your Honor.
Oh, okay. Yeah, I see workers. I've got the jail here for the Gibson case. I'm certainly willing to try the phone number, but it doesn't look like he's logged in, Ms. Bordeaux. All right, well, let's it looks like everybody who's logged in has been admitted to the hearing. So we have Ms. Tucker represents the petitioner. Mr. Brown is LGAL. Ms. McCluskey represents mom. Mr. Hotchkiss was appointed to help dad establish paternity, but he's not been able to make contact with the father. And Ms. Bordeaux was here on behalf of the agency. As far as you know, the phone number on the petition is accurate, Ms. Bordeaux?
I don't believe there is a phone number on the petition because when I
I've-
filed it, I
I've
didn't
written-
have a number.
All right, I've written that phone number in. That's a 734 exchange. I must have gotten that at a prior hearing.
I think we may
It's
have
not the-
received that from him.
All right, let me try that.
Please leave your message for 734-334-8545. Sorry, mailbox is full. To send an SMS notification, press 5.
Well, so much for that. I'm assuming whatever that option was to send a text message. Did you try that, Mr. Hotchkiss?
I didn't. I wasn't really sure what it was.
All
I
right,
usually, even if a mailbox is full, the recipient will see the phone number that was called and call back, and that's kind of what I'd hoped for. I called it a couple times.
All right. So we had a lengthy off-the-record conversation among the attorneys about our scheduled trial date in a week, and the fact that we have not yet sent this putative father notice of a putative father hearing, although he has participated in at least, well, I think, Ms. Bordeaux, you said in every prior hearing he's participated?
Yes, Your Honor.
All right, and I think he's indicated that he believes he is the biological father of this child, but he hasn't done anything to try to establish it. If he simply filed a notice of intent to claim paternity, that would be, he has done that?
No, he has. So he participated in the DNA testing, and we're waiting for those results. So he is going through the steps, but I'm not sure that he knows he needs to file anything.
Ah.
Yeah, I learned all that in talking to Ms. Bordeaux during or by email through the Ball case. So I wanted to update the court as to that.
All right. So I'm going to make just a little bit of a record here today. Ms. Bordeaux, if you could raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Haley Bordeaux.
So, Ms. Bordeaux, you've had some ongoing contact with Mr. Brandon Miles concerning his status as the father of Aresian Ellsworth?
I have during the investigation. As of lately, it's been the foster care worker who's been communicating with him on a regular basis.
And is that Jackie Johnson?
Yes, Your Honor.
All right, for some reason, I don't see her logged in today. Let me double check. Make sure I didn't miss it. No, she didn't log in. Well, let's find out what you know. You've already indicated that he's submitted to a DNA test?
Yes.
And was that something that Ms. Johnson arranged for?
Yes.
You have had communications with him yourself, correct?
Yes, I have.
And during the course of your investigation, he indicated to you that he believes that he definitely is the child's biological father?
Yes.
All right. So we've run into a snag here. One, he's not answering his phone and not responding to these calls. The other problem we have is we've had a notice returned that was sent to the address shown on the petition. Do you have an updated address for Mr. Miles?
I do not, but I can double check with the foster care worker, and if anything has changed, I can let Mr. Hotchkiss know of any changes.
If you could, and let Shannon know as well, I guess let everybody know, if there's an updated address, the address for which we're getting return mail is 9114 Everest in Detroit. So clearly, the post office doesn't know it's living at that address, because they returned the mail to us without a forwarding address. So if we could get that address, and then once we get it, I am going to send him a putative father notice so we don't lose any more time on this case. But clearly, we're not going to be ready for a trial in a week. There doesn't seem to be any great urgency here because, at least from the mother's perspective, she's basically disappeared.
Your Honor, I
and-
represent Mom on this one. Last I knew, she was in Kingswood.
I also have an update. So she was
Go
discharged
ahead.
from Kingswood, returned to Jackson, and then had to be hospitalized again. And it's my understanding that she was recently admitted to the Odyssey House.
Yeah. I'm not seeing anyone from Odyssey House logged in.
They may not.
All right.
If I called there, they wouldn't confirm or deny she's there. So we're still on this.
Yeah, I understand their protocol. So, go ahead, Ms. Bordeaux.
It's been very difficult to work with Mom because she's struggling with delusions. So she, at times in the past, has refused to talk to me because she thought that I was the devil. And then I know that she also thought Jackie Johnson, the foster care worker, was somebody else and didn't want to speak with her anymore. So it's been a constant battle. I'm not sure if she will sign a release for her attorney because she's really not in the right state of mind.
But you're certain she is at Odyssey House in Flint?
That's what Jackie Johnson, the foster care worker, told me earlier, or last
right.
week on Friday.
So let's put this pretrial over for 2 weeks. Hopefully by then we will have the paternity test results back. Let's get out a putative father notice to whatever address that we're able to get for Dad. We will set a putative father hearing in, let me look at my calendar.
Your Honor, if we're not able to get a different address for Dad, can your order include permission to publish putative father notice? Okay, thank you.
Yes. So let's see. So the putative father hearing will be on July 6th.
We're not here.
Oh, I'm sorry, July 13th.
At what time?
Let's set it for 9 o'clock. Include in today's order that if we don't have a good address, if we can't get a good address for Dad, that can be published.
Thank you.
And that gives plenty of time to do that. Ms. Bordeaux?
The agency was also asking for permission for DHHS to consent to medical care for Horizon if Mom cannot be located or if she's not in the right state of mind to give informed consent. They've run into this issue already a few times.
I will certainly authorize that. Whatever care this child needs, if the mother cannot be reached or is unable to make a rational decision that the agency certainly can authorize medical treatment. Anything else today?
Pretrial date.
2 weeks.
2 weeks, 8:30.
Time.
So that's June 22nd at 8:30.
Thank you, Your Honor.
All right, thank you, everyone. I think we're ready for no, we're not. Yes, we are.
Can I have that other file too, please?
Yes, sorry. All right, so we've got a post-term for Brittany McLean.
And I apologize, Your Honor. I couldn't find who the worker was on this case.
Should be on the report. Hold on a minute.
Well, I also searched my.
Osborita Norman is the adoption worker, and she's here. Get her in. And interesting. I don't see. The only other name listed on the report is Dana Poliziani, and I don't think she's here. Let me ask, Ms. Norman, have you been in contact? Well, it lists you as the foster care worker and the adoption worker. So I guess we have everyone here.
Yes, and Dana is the POS monitor, so I don't think she's going to be joining us, but I am the worker.
Okay, wonderful. And let's see, Ms. McCluskey is LGAL. Ms. McCluskey, how's Brittany doing? And I'll ask Brittany that in a minute.
Actually, I reached out to placement, but I was not able to reach placement, so I'm glad that Brittany's here. I did review the report. I did get an update when she was placed with her pre-adoptive home. So I'm just really, really happy to see this. I'm really happy to see that it appears she's doing well, because obviously we all know this has been a long road for these girls, especially Brittany. So I have no objection to the goal of adoption. Thank you.
So Brittany, how are you doing?
I'm doing good.
That's good to hear. Is there anything you'd like to ask me or tell me?
No.
Ms. Norman, what's your perspective on how Brittany's doing?
Brittany's doing really well since placement in her pre-adoptive home now. It started off as a foster placement, and the family signed an intent to adopt on the 14th of May. There are no concerns in the home. The family's doing really well with Brittany. She has summer school coming up. She has some camp that she's registered for. She got hired at Jimmy John's in Ann Arbor. She has not been able to start working yet because we are working on getting her a social security card and her birth certificate, which I was able to obtain last week. So I finally got her medical records from her physician on yesterday, and I'm able to send off the request for a social security card so that she can have identification and get a state ID so that she can start working. Other than that, she's caught up on medicals. I've been seeing her monthly. She's doing great. She's bonded really well with the family. And she is in love with the 3 dogs that are in the home. They are like her, they are a form of her therapy. She is also participating in therapy, which is going really, really well as well, and receiving services from CMH.
This is all very good to hear. It's been a long road for Brittany. Glad to see we're making some good progress. I will implement the recommendations. We'll set our next review hearing for September 7 at 8:45.
All right, sounds awesome. I will see you guys then.
Thank you, everyone. Brittany, you have a good day.
You too.
Thank you. And next up is Christian Gibson. So it looks like I've got a parent in jail. Must be dad.
This is a case closure if it's still, okay, thank you.
And Debbie Potter, let me get her in. Okay, so we've got Kelly Tucker representing the petitioner. Father's represented by Mr. Brown, mother by Mr. Kelly, and Ms. McCluskey is LGAL, and Debbie Potter's here on behalf of the agency. So, Ms. Potter, is it still your recommendation for case closure today?
Yes, it is.
Any objections to case closure?
Objection.
No.
No, Your Honor.
Very well. I will sign the order terminating the court's jurisdiction today.
It looks like Mr. Gibson was trying to get the court's attention.
May I say something, please?
You may. Go ahead, sir. Sorry.
Is there any way we can get it to where I'm able to talk to my son?
While you're in jail, you mean?
Yeah, because every time I call my parents' house, and if they have my son, they're going by what Miss Whitney's saying and saying that I'm not allowed to talk to my son because that's what you guys are stating.
I'm terminating jurisdiction today, sir, so that will no longer be a problem.
Okay.
Whether or not they choose to allow you to talk to your son will be totally up to them. So if they're willing to, there won't be any order in place after today that would restrict that in any way.
Okay, thank you.
You're welcome. That concludes our hearing.
Okay.
And that brings us to Cavender. Let me bring Mr. Chris Davis in.
For right now, the other witnesses can stay in the waiting room, Your Honor. I'm hoping to get everything through Mr. Davis.
Okay, let me bring Mr. Cavender in. And let me see if Mother's in the waiting room. Yes. Ms. Smock, are you able to hear me?
Yes.
So we're still waiting on Mr. Cavender's audio connection. Kelly, is there anybody else I should be bringing into the hearing at this point?
No, like I said, I'm hoping to do everything through Mr. Davis. So we can bring them in later if they're needed.
Okay. Now we're still struggling with Mr. Cavender's audio connection. I do have a phone number listed for him. I can try to call him. If there's somebody that could shoot him a quick text and let him know to answer his phone, we might be able to speed the process up. Mr. Cavender, can you hear me? Not getting any sound. Call didn't go through. Let me try it again.
Your Honor, I just texted him to answer his phone.
Thank you. Mr. Cavender?
Yeah.
This is Judge LaFlamme. We were having trouble establishing an audio connection with you. If you're okay with participating by phone, this works fine for me.
Yeah, that's okay.
Okay, so we have Kelly Tucker representing the petitioner. Mr. Kelly's LGAL. Mr. Cavender is represented by Ms. McCluskey. And on behalf of the agency, we also have Mr. Chris Davis present. Anything preliminary, counsel?
No, Your Honor.
I would very, very quickly, Your Honor. The court, if I could, I may need to speak to my client in a breakout room if the court doesn't mind. It would be brief. Just as a quick reminder, before our pretrial, I was not able to get a hold of my client because his phone was not accepting restricted calls and I was working from home. I did get to talk to him about a plea. It was his intent at that time to enter a plea, but he wanted a little more time to think about it. I did try 4 more times to call him from my office, so it wasn't restricted. And his box is not set up, so I have not been able to reach him despite several attempts. So however the court would like to proceed, I can't proceed with a trial really without talking to him.
Sure. So Mr. Cavender, your attorney would like an opportunity to speak with you right now before we proceed with the hearing. What I'm going to do is hang up this phone and then she's going to call you. And then when she comes back on and lets me know that she's spoken with you, I'll redial your number. Okay.
Okay.
All right.
Thank you.
Go ahead, Ms.
Can you
McCluskey.
put me into one with my client too, as long as Ms. McCluskey is?
I can.
Thank you.
For some reason, I didn't have you listed. Let me write that down. Okay, Ms. Smock, I'm creating a breakout room that you and Mr. Brown can have a private conversation in. What you need to do is follow the instruction that appears on your screen. You'll get a prompt to go into that breakout room. And then when you're done, there's another prompt you can hit. It'll bring you back into the courtroom. So I am creating that breakout room right now. So is Louis Eubanks still on for a trial? Or are we doing a pretrial? Seems like I had a conversation about that.
Yeah, I don't know. I think I just put down pretrial because nobody really told me. So
I think that's what it is. And I can't remember what the issue was. Oh, I do remember. Yeah, it's definitely not going to be a trial. So, do you use the Outlook web?
I use Outlook for email.
So you use the standard Outlook program, not
Just the
the.
application, yeah.
You don't use the web app.
I don't.
Shannon, you use the web app though, don't you?
yeah,
Have you figured out what happened to the calendar? Or don't you use that
I don't
calendar?
use that calendar.
See, that's the one that it syncs with the one on my phone. And this new web app, I don't see a calendar on it.
We're ready to proceed whenever the court is ready, Your Honor.
Oh, there it is. It just didn't appear in the menu like it did before. All right. Let me get him back in. And it looks like Mr. Brown and his client are back. So let me dial Dad's number again.
I'm sorry, but the person you called has a voicemail box that has not been set up yet.
Mr. Cavender, can you hear me?
Yeah.
Okay, well, good. We've got you in the Zoom hearing now. All right, Ms. McCluskey.
Thank you, Your Honor. So it is my client's intent to enter a no contest plea this morning. And I did ask Ms. Tucker if she had the 154, the dispositional
Oh.
finding handy.
I'm sorry, I didn't see that.
Oh, that's okay. I'm also looking. I think
Mr. Davis, could you resend that to us quickly?
oh, actually, I do have it, Kelly. I'll forward it to
perfect.
Shannon.
Thank you.
No problem. Thank you.
Mr. Brown?
Judge, based upon that fact, I have never thought that mom should be a respondent in this matter. I can make the argument to the court, and then the court can see fit whether we should proceed to a trial.
All right, well, let me go ahead and take Dad's plea and get that out of the way, and then we'll address Ms. Smock.
I just forwarded the 154 to Miss Carol, and it would be page 19.
Okay, thank you. Okay, Mr. Cavender, we lost your image. Can you still hear me?
Yeah.
All right, could you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you could put your hand down now. Could you please state your full name for the record?
Trevor Cavender.
You are the father of McKenna Cavender, born December 11th of 2018,
Yes.
and of London Cavender, born January 24th of 2020.
Yes.
Were both of these children found in the county of Jackson when the petition was filed?
Yes.
Have you read the petition, and do you understand the allegations against you that are made in it?
I haven't read the petition, no.
So you don't need to have to respond to admit or deny any of these allegations, but I want to make sure you're aware of them.
Okay.
So one of the things the petition states that on December 16th of 2019, that you were struck in the head by Lauren Smock while holding McKenna. It states that on February 20th of last year, that you were arrested for another domestic violence charge and sentenced to 43 days in jail after pleading guilty on March 30th of 2020. It also says that Michelle Rosenau of Recovery Technologies expressed concerns about your behavior interacting with others during the sessions, and that Judge Mazur ordered that you restart the program due to new domestic violence charges. On October 19th of 2020, the petition says that you were found outside Lauren's home and it led to your arrest. It says on December 30th of 2020, a domestic violence incident occurred between you and Ms. Smock, and that you were taken into police custody on January 9th of 2020. I mean, there are other things in the petition, but I'm only reading the ones that directly implicate you. All right, I think I covered the primary allegation. So you understand now what the petition alleges that you did, correct?
Yes.
Okay. If the court accepts your no contest plea today, there will not be a trial, and you would be giving up the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you understand you will be giving up all these rights if I accept your plea today?
Yes.
If the court accepts your plea today, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your children temporary wards of the court, place them with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines that you are unable to provide your children with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you understand each of these consequences?
Yes.
If your parental rights are terminated, your obligation to support each child will continue until the court modifies or terminates the obligation, until an order of adoption is entered, or until the child is emancipated by law. Appellate review is available to challenge an order of disposition following adjudication, and such a challenge can include any issues leading to the disposition, including errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions about anything I've told you so far?
No, sir.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No.
Are you entering this plea of your own free will?
Yes.
Do you understand that I will treat your no contest plea the same as I would an admission of responsibility?
Yeah.
And Ms. McCluskey, my understanding of the reason for a no contest plea is potential civil or criminal liability.
Correct, Your Honor, sorry.
All right, Shannon, do you have that printout? Doesn't look like she got it, Rebecca.
Check my sent.
Yeah, sometimes attachments get captured by our aggressive spam filter.
I'll pull that one page out and try to resend. It was the correct email address. It looks like it went through. Maybe a smaller attachment will.
I'll also try to send it.
It says I have 2 emails, but it's not there.
Really? It's not opening.
It's saying I have 2 emails that I haven't read. One is Amy and I don't have the other one.
Oh, I got you. It's not telling you you've got these emails. That's what I thought you were saying.
Okay, I just pulled that one page out, so it's a smaller attachment. Maybe that will help.
What page did you say that was, Rebecca? 19?
Yes, yeah.
Okay. I'll also send the copy that I have.
Bless you.
Thank you. Excuse me.
Still nothing has come through. Can you try copying the relevant language and pasting into the body of an email? Will it let you do that?
I can try that.
It's the attachments that are apparently creating the problem. There have been some changes to our email server in the last few days, and I'm afraid maybe that might be complicating things.
Okay, I just did that. I copied and pasted and just sent.
That will probably come through. Check on that one, Jimmy.
There we go.
All right, looks like that worked. Just print the whole email.
you want me to write here?
Petitioners Exhibit 1.
I don't have it.
Respondent 1. Thank you. All right, we've marked Ms. McCluskey's email, which contains an excerpt from the CPS report as Respondents Exhibit 1. I'm going to read that briefly to myself. All right, I've reviewed Respondents Exhibit 1. Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes, Your Honor.
I do accept the plea. I find that it was knowingly, understandingly, and voluntarily made, and that the record supports that one or more of the statutory grounds alleged in the petition are true. So let's turn to Ms. Smock. Mr. Brown? You wish to address the court?
Yes, Your Honor. This case has been an in-home case from day one, filed on March 17th, 2021. We had a probable cause hearing, and the court indicated that they felt that there was probable cause. All of the allegations in this matter are historical and occurred back in September or October. Long before this case was filed, Mom was doing everything that she was supposed to do. She's continuing to go through services, Lifeways. The kids have never been out of her care. This case was filed for the sole reason there is a new policy that indicates that if it's a prevention case and the individuals do not do to CPS's satisfaction, then it gets reclassified to a higher level classification, and their directive is to file a petition, regardless of whether the case meets the statutory basis of the children being in substantial risk of harm. Or the other reason that is checked on the box, the home environment by reason of neglect, cruelty, drunkenness, criminality, or depravity, is an unfit place for the children to live. Obviously, those two allegations do not apply, as we're now 3 months into this case. Children are doing well. The court has jurisdiction. I just don't believe Mom rises to the level of a respondent with regard to the domestic abuse. I've read all the police reports. She did everything that a victim is supposed to do in the months preceding the filing of this petition. I think Ms. Tucker agrees with me, but is hamstrung by that policy directive. And I don't think that's right, that lawyers are required to file, when they file pleadings, that they have some basis in fact or law to file them, not based upon some policy directive. I find that you have a policy, but it still must have some basis in fact and law that these children are at substantial risk of harm. Obviously, they're not. For those reasons, I would ask that mom not be made a respondent. We have jurisdiction. Obviously, they're okay. They've been there since day one, and there's been no removal, or haven't heard one peep that anything is amiss with her home or mom. Thank you.
Your Honor, if I may respond.
I think I need to hear testimony before I can act on Mr. Brown's request. So if you want to call your first witness, we can do that.
Sure. My witness is going to be Chris Davis.
Mr. Davis, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the
I have
truth, so help you
questions
God?
of that.
Yes, Your Honor.
You can't just jump in, whoever you're saying that. You cannot just jump in. It's like we're in court.
Yeah, that was Ms. Mock. Ms. Mock, I'm taking testimony right now.
Are we ready to proceed, Your Honor?
I think we are.
Okay. Mr. Davis, can you state and spell your name for the record?
Yes, Christopher Davis, CHRISDAVIS.
Thank you. Mr. Davis, you are employed by the Department of Health and Human Services.
Yes, ma'am.
Is it through that capacity that you became involved with the minor children McKenna Cavender, date of birth December 11th, 2018, and London Cavender, date of birth January 24th, of 2020?
Yes, ma'am.
Is it your understanding that the legal father to those children is Trevor Cavender, date of birth December 16th, 1999?
Yes, ma'am.
And is it your understanding that the mother of those children is Lauren Smock, date of birth April 13th, 2000?
Yes, ma'am.
Okay. Tell me how you became involved with this family.
I became involved with this family due to there was a new complaint where it had been sent to ongoing. I was the ongoing worker that was assigned to the case. And that's how I started.
Okay. Fair to say this was like you said, an ongoing case before this petition was filed?
Yes.
What sorts of issues rose to it being an ongoing case?
So there were ongoing mental health issues for Lauren, and there was ongoing domestic violence issues between Lauren and Trevor.
Okay. At some point during the ongoing case, was a decision made to file a petition making both parents respondents?
Yes.
Was that decision?
Ms. Tucker, I need to interrupt. The mother has disappeared from the hearing. I wonder if she was about to tell me that her phone was going to run out of juice. She's gone. Let me see if I can get a hold of her. I don't know what happened. Is this Ms. Smock?
This is, and I don't think it's appropriate that I was kicked out of the call.
You weren't kicked out. You just, for some reason, I saw that you disappeared from the screen. It wasn't something we did. We just lost it. So as soon as I noticed you were gone, I stopped the testimony, and that's what prompted this call. So you weren't kicked out, ma'am. I don't know. I'm not sure what happened. Do you want to try to Zoom back in, or do you want to just participate by phone?
I'd like to participate by phone. That was my question. I have an appointment at Lifeway in 10 minutes.
Okay.
So that's why I needed to only use the phone to be able to drive my appointment.
Yeah, no problem. You can participate by phone. All right. I'm sorry. Go ahead, Ms. Tucker.
That's okay. Mr. Davis, you had mentioned that domestic violence and mental health concerns were present with Ms. Smock.
Yes, ma'am.
What kinds of services was she offered in the ongoing case?
So she was referred to FTBS, Family Together Building Solutions, with worker Jason Belaski. And she had also been referred to Lifeways, where she had worked with Nikki Winans and other Lifeways workers.
Was her, well, let me ask you this. How did she do in completing those services?
So Jason Blasky had discharged her for the fact of lack of follow through. And when remaining in contact with Nikki Winans, she had also stated that there were issues of lack of follow through and making sure that she had taken her medications, which had led to the various times where she had reported to myself that she could not properly care for her children due to her mental health.
Okay. So if I'm understanding you correctly, it was an issue that Ms. Smock did not follow through on some of the services that were offered?
Yes, ma'am.
Okay. And you had mentioned certain statements that Ms. Smock had made to you. Can you give me more detail on those?
Yes, I put that in the petition of the fact that she had called me numerous times and stated that she needed me to find social support and asked if I could reach out to others so that she could get somebody to care for her children so that she could go ahead and on one occasion, I believe she said that she was going to go to Henry Ford, and then another occasion where she said that she was going to go to Lifeways and seek out assistance with her mental health.
Did she ever make a statement to you that the children were too much for her to handle?
Yes.
That's leading.
It was a leading question.
I'll move on, Your Honor. Did Ms. Smock ever present concerns of self-harm in any way?
I'm trying to recall. Yes, she had reported that she had suicidal ideations and that she could not properly care for her children due to those facts.
And do you recall about when that conversation took place?
I do not recall. I would have to look through the petition and see those details.
Okay. Were there ever, let me ask you this, was there a safety plan in place as part of the ongoing case?
Yes, there was a safety plan that she would remain in contact with her therapist, remain in contact with the Lifeway crisis department, remain in contact with myself, and then also keep in mind that we had support persons that were selected between myself and her that she would contact if the children became too overwhelming due to her mental health concerns.
And did any concerns arise regarding that safety plan?
Yes, there were the times where she had contacted me again that she could not properly care for her children due to her mental health, and that she needed me to contact these support persons to try to find somebody to care for the children.
Is it fair to say that these statements were made more than once?
Yes.
Would you be able to give me a rough estimate of how many times those statements took place?
I believe it was 3 times.
Thank you. No, you had mentioned Ms. Smock's mental health medication. Was there ever a plan as to that she could show you she was taking her medication?
Yes, and I attempted on numerous occasions to verify that she had the medications and the proper amounts. And typically she would say that it was either at her grandmother's or that she had not filled the prescription.
Were you ever provided proof regarding medication?
I think twice I was provided proof of the medication. I can't recall how many times that I was not provided. It was definitely more times provided no proof than provided proof.
Okay. Mr. Davis, are there any other concerns regarding Ms. Smock that we haven't discussed?
Not at this time.
Okay, thank you. I have nothing further, Your Honor.
Questions, Mr. Brown?
Yes, Mr. Davis, can you pull up your, because one of the questions that Ms. Tucker asked, I'm going to follow up on. Can you pull up your petition?
Yes.
Okay. Tell me when you're ready.
I'm ready.
This petition that you filed was filed on March 17th of 2021, correct?
Let me pull that page up.
That's the date that appears on the petition, Mr. Brown.
And yes.
And I discussed this a little bit in my argument before court, but you're a CPS worker, correct?
Yes.
And you're aware of the fairly new policy directive regarding prevention cases?
For the investigations, yes.
That if in a prevention case, that if the party does not do services to your satisfaction, that it's reclassified at a higher level and a petition is to be filed. Is that a fair statement?
From my understanding of the policy, it is more correlated with the actual child protective law, which was best practice in the past, but is now the new policy.
When you implement that policy, do you take into consideration whether the children meet the statutory basis of filing a petition, that they're at imminent risk of substantial harm, or the other matter where because of criminality, depravity, that the home is unfit?
Yes.
Do you do that analysis?
Yes.
So are you telling me there are times with that policy that you can preempt the policy and not file a petition?
So this is a mandatory petition at that point with the new policy.
That's what I mean. You have no discretion whether to file a petition or not, even if you believe in your heart that it doesn't meet the statutory basis. You consider it mandatory.
I believe that if we feel that it's not meeting the criteria, that no, it would not be the mandatory petition at that time.
Okay. The children have never been removed from mom, have they?
Not to my knowledge.
Is that something you would know? You're the one that has to file the removal, wouldn't it?
So if with past CPS investigations, I did not see a removal in the CPS history.
Okay. And when we were talking about those issues of mom having some crisis, those are fairly historical. My petition reads in October or November, and I'm referring to H and J. Those were those instances where they occurred to you.
So with those instances, yes, her mental health is a concern, and those were the times that she had stated that, and that when at a later date, when she had stated that she was out of medication, that was the reason why it heightened the concern.
Okay, I know you have concerns, but those are historical when she said those things to you. Is that true?
It
In
was within
October or November?
But it was still within the reporting period of the petition.
That's not what I'm asking you. They occurred in October and November when those statements were made to you that she said that she couldn't care for her children.
That is when they occurred.
Okay. Since that time, did you ever observe, did you go into the home and observe the kids after November?
Yes, I have.
Okay. How often did you go into the home and observe the kids?
We meet with the family at minimum four times a month since the petition was started.
Okay. Well, let's talk about before the petition was started. How often did you go in before the petition was started?
That was 3 times a month at minimum.
Okay. Did you ever determine before the petition was filed that the children were of substantial risk of harm or the home was unfit enough to remove the children?
So speaking with worker from FTBS, Jason Belaski.
That's a yes or no question. Did you feel it that the children were of substantial risk or the home was unfit enough to remove the children?
No.
Okay. And as of this day, after the petition was filed on March 17th, you indicate you're in there 4 times a month?
Yes.
Is mom employed?
She's inconsistent with employment. I believe she is not employed currently from what she stated.
Okay, but she has been periodically employed during the course of this case.
She bounces back and forth.
Okay. Since you've been in there since March 17th, have you ever found the home? Let me put this first. Has mom done a whole lot better since the petition's been filed?
She's done better with some of the concerns there with interaction with herself and Trevor, but it is sometimes her actions and her statements lead to believe that there is still some ongoing issues with her mental health.
Okay, but you haven't found them at substantial risk that the children be removed, correct?
No.
With regard to the domestic violence, after November, Miss Cavender has done everything correctly that a domestic violence victim should do. Would that be a fair statement?
No, there was a safety plan that she would not open the door for Trevor Cavender, and she did not do. That she would call law enforcement immediately, and she struggles to do that. She has typically allowed Trevor into the home, and that is one of the concerns as well.
Have you read the police reports?
Yes, I've read the police reports.
Okay. Did you read? I've never read a police report that indicates that she voluntarily let him in. Where are you deriving this information?
So that was the police. Let me pull the police report up.
According to the police report that I read, she was surprised and opened the door, and he walked in on his own.
So from my understanding of a common apartment that's got a peephole, I would lead to believe that would be able to be seen by looking through the peephole.
Absolutely, but you're assuming that she looked through the peephole.
She had stated to me that she had looked through the peephole prior to opening the door.
She called the police, didn't she?
She contacted the police after allowing him in the house.
Okay,
The
you're
safety
using
plan, the safety plan was to contact police before entering the home.
Okay, I assume she messed up and opened the door, whether it was voluntarily or involuntarily. She called the police.
She ended up calling the police.
Okay, to your knowledge, she has not had any more contact recently with Mr. Cavender?
Yeah, she has had contact with Mr. Cavender. She
At
was just
her-
recently at her grandmother's.
Okay, did he come over? Did she allow him to come over? Did she allow him to come over?
Yes,
And how do you know that?
she had just spoken with me just, I believe, 2 days ago on that.
How did that transpire?
There was an argument between herself, her grandmother Phyllis Morgan, and Trevor regarding Trevor.
How did Trevor end up coming to her grandmother's home?
Because they decided that Trevor was going to move in there, and that's why we had to change the safety plan, that she would be gone before Trevor came to and from the home to make sure that there were not going to be any further issues.
Okay, that sounds like an accident to me. That doesn't sound like something that that she facilitated or something she did wrong to meet up with Trevor Cavender. Is that a fair statement?
To me, an accident would be meeting at the home, but it would be a fair statement that she would leave following the fact that she knew that he was in the home.
And she did leave, didn't she?
She didn't know that there was an argument, and then she left the home.
I guess we're getting caught up on, you wouldn't expect her to be mad and argue that why is he here? And then just immediately leave?
Not with their history, no.
Thank you, Judge. No further questions.
Any redirect, Ms. Tucker?
Yes, just briefly, Your Honor. Mr. Davis, in regard to this policy, is it still a step you must take to have the petition reviewed by someone in the prosecutor's office?
Yes.
Did you do so in this case?
Yes, I did.
Okay. And was that petition reviewed and approved by myself or Mr. Way?
Yes.
Okay. It looks like your petition indicates that Mr. Way approved this filing.
Yes.
Okay. And then it sounds like you just changed the safety plan in the past 2 days.
Yes. We had changed the safety plan when Trevor stated that he was going, when Lauren and Phyllis stated that Trevor was going to move, and I haven't been able to stay in contact with Trevor. But once they had stated that he was going to move into Phyllis's home, then we had changed the safety plan. I cannot recall the exact date. I believe it was sometime last week.
Okay. And just so I'm clear, was the plan only for Trevor to move into Phyllis's home?
Yes.
Okay. And Phyllis is Lauren's grandmother?
Yes.
Okay. So what's the, I guess that's irrelevant. I have nothing further, Your Honor. Thank you.
And I'm sorry, Ms. McCluskey or Mr. Kelly, I neglected to offer you the opportunity to question the witness.
I have no questions, Your Honor. Thank you.
No questions, Your Honor. Thank you.
Any further testimony to present, Ms. Tucker?
No, Your Honor. Thank you.
Any presentation, Mr. Brown?
No, Your Honor.
Arguments, or you already made your argument, Mr. Brown?
Yes, I think it still stands that just because she's not perfect doesn't mean that it rises to the level of a substantial risk of harm or it's an unfit home. by the very nature that the children are there, and removal is not sought. And it looks like things are much better than they were 6 months before the petition was filed of these historical allegations, that those conditions don't apply any longer. So we would ask that she not be made a respondent. The court has jurisdiction, but there's no need for her to be a respondent at this point. Thank you.
Ms. Tucker?
Thank you, Your Honor. I would disagree. I mean, on one hand, Mr. Brown is right. This is a unique case in the sense that it was an ongoing case that we chose to file on. My office was clearly consulted about filing on that case, and Mr. Way did approve that filing. If there was an issue, I'm sure it would have been discussed at that time. In regards to mom, there were domestic violence issues in the home, which Mr. Davis testified to is what led to DHHS getting involved in the first place, in addition to mom's mental health. We don't quite know, at least my understanding of the testimony is we don't quite know where mom's mental health stands today. Mr. Davis has indicated that she has not participated in services, has not been seeking treatment, and to his knowledge has not been taking her medication. That's concerning to me in conjunction with her statements to Mr. Davis that she can't handle these kids by herself, as well as that she's had suicidal ideations in the past, and some indication of self-harm. I understand those are historical in the sense that Mr. Brown obviously acknowledges that this happened before the filing of the petition, but I still think that's significant to take into consideration. Perhaps even more concerning, given the allegations of domestic violence, is that there continues to be contact with dad. I understand that Mr. Davis has been in the home and there has not been, at least in his opinion, reason to remove these children, but that's not unusual. The court adjudicates on children that haven't been removed frequently. So to use that as the basis as to not to adjudicate seems a little silly to me in the sense that we do that quite often. Other than that, like I said, there continues to be concerns. I would like to see mom get some services to ensure these kids' safety. And with that in mind, I would ask that the court adjudicate. Thank you.
Mr. Kelly?
Your Honor, these kids are 2 and 1 years old. I think the most important thing for them is to stay with their mom. I'm kind of on the fence with this one. I didn't really hear needs that needed to be addressed that were present. It sounds like it is historical. I'm not sure what things mom has done on her own to try to address these situations, whether she's involved with AWARE, she's done counseling on her own. I don't know if that's happened. Certainly whether it has or hasn't happened, she can either voluntarily do it or with the court already having jurisdiction, she could be involved with it. For her to be made a respondent, not respondent, I don't think it changes the complexion of this case dramatically. I think she'll still be able to have services available to her to address those issues if the agency felt or feels that they currently haven't been addressed. So I think you already have, I agree, you already have jurisdiction based upon the plea by dad. I think we can move forward with this. I would leave it in the court's discretion if you want to make her a respondent or not. I would think if these were significant enough, those children would have been removed a while ago. So that speaks volumes, I think, for me, considering the amount of weight given to the historical issues that mom has had. Thank you.
All right. Thank you, counsel. It really sounds to me, Mr. Brown, like you're conflating the standard necessary to remove children from a home with the standard for the court to take jurisdiction. I frankly have been very pleased over the course of the last year or two with the leniency shown by the agency in both initiating cases and in seeking removal of children from the home. And their approach has been early intervention. Let's get into these homes. Let's work with them well before we talk about filing a petition. And let's not remove children unless we absolutely have to. What I've heard today is absolutely classic. We've got early intervention, and that's great. I applaud the agency for its early intervention. And then we have parents, based on the testimony, who are definitely making some efforts. And I don't want to discount that. They definitely are making some efforts. But the efforts are still not sufficient, that relying upon them simply voluntarily to follow safety plans wasn't enough. Under the standard you're advocating for today, I don't think I could ever adjudicate an educational neglect case, because we never talk about removal. Well, I say never. There has been one where we talked about removal, but for the great majority of ed neglect cases, we don't consider removing children from the home, but we still take jurisdiction because there's something wrong. There is something wrong. Parents are making efforts to address it, both in the areas of domestic violence and in the area of mom's ongoing mental health treatment. I don't know if anybody noticed, but I'm pretty sure what mom said when she had to go to telephone versus live participation in the Zoom hearing is that she was on her way to an appointment in Lifeways. I think I heard her say that. That's great. That's what we want to see. So the petition wasn't filed to remove these children from the home. The petition was filed so that the court could take jurisdiction. So we're now no longer looking at voluntary participation in a plan, but we're looking at under the authority of the court. I think the evidence has established indeed that there are conditions in this home that make it an unfit environment for children, both with respect to mom's ongoing mental health issues and her ability to address those issues without direct court involvement. Yes, she's making an effort. That's appreciated. It's encouraged that she continue. There's ongoing struggles with domestic violence, and we all know the danger to children of being exposed to domestic violence. Even children as young as this, they don't know how to process it. I believe a factual basis has indeed been established to allow the court to take jurisdiction as to both parents. I am going to adjudicate dad based on the plea, mom based upon the proofs presented today. Are we prepared to move forward with disposition today? Because I want to move this case along. I don't want to keep these parents involved in court any longer than absolutely necessary, but I want to make sure that they don't ever come back here, that they've got all the tools that they're going to need in order to be able to address the problems that are involved in this case. So, Ms. Tucker, do we have a foster care worker present?
Mr.
In the
Davis,
home.
Yeah.
There is no foster care.
Oh, that's
worker.
right.
So I will be doing disposition, Your Honor.
Okay. And are you prepared to provide the court with your recommendations for disposition today?
Yes, Your Honor.
Go ahead.
So yes, Your Honor. So my recommendations for mom is a psychological evaluation and to follow all recommendations. For families first, parent education, with following all their recommendations, participation with Lifeways and to follow all of their recommendations. And then for dad, psych eval with recommendations, families first, parent education with following all of their recommendations. And then with due to new information regarding substance abuse issues of Trevor, the department would like to successfully rule this out and is asking for random drug screens be within the court order and the cooperation with CPS on that fact. We understand that that's going to obviously be in your discretion, but that is the recommendations.
You didn't ask for a substance abuse assessment for Dad. Has there been one previously?
No, not at this point.
I think that if there's enough of a concern to ask for random screens, I think there's enough of a concern to ask for an assessment. And maybe
Yes,
the
sir.
assessment would rule out the need for random screens.
Yes,
But,
Your Honor.
Substance abuse assessment and follow the recommendations, I think would be appropriate. Counsel, do any of you wish to weigh in on the recommendations?
The recommendations are fair.
I just, to clarify, Your Honor, you're not ordering the random screens unless the assessment finds it necessary. Is that correct?
Correct.
Okay, no objection.
Okay, so we're going to set our first review hearing for
September 7th at 8:45.
September 7th, 8:45. And let me say to both parents, I hope you're both listening. These, despite the fact that I did an adjudication, these are not criminal proceedings. The purpose of all the involvement that you've had is to try to fix problems. Our goal is to provide you with all the tools that you will need to deal with these issues that you're struggling with and get you to a point that you've got the tools available to help you to deal with these. My desire for both of you is that as soon as possible, once we're confident that you're fully addressing these concerns, that I can terminate jurisdiction and you can get on with your lives. It's not punitive. It's designed to help you. That's going to be my outlook throughout this case. I wish you both well. I want you both to get on board fully for the sake of your children. The very best place for your children is where they are now, in your home and in your care. We want to keep them there, but we want to keep them safe there. So I wish you well. That concludes our hearing today. Everyone have a good day.
Your Honor, could I just address one misstep that I misspoke?
Yes,
Can I clarify
go ahead.
that? So it's Family Services and Children's Aid for the Parent Education. I apologize. I said families first.
Oh, thank you.
Are we meeting at 1:15 today? I was kind of confused.
Yes.
I know the case was canceled. Somebody say yes?
Yes.
Yes.
Okay, I'll see you then.
It's going to be essentially a pretrial to discuss the issues that have arisen.
Okay.
We didn't know if we were going to be able to get everybody here to do it this morning. So we just decided to keep it on the calendar and we'll address all of the issues this afternoon.
Fine, good deal.
And
See you this afternoon.
I think it's set for 1:15. All right, have a good day.